Okay. Good evening, everyone. Welcome to the Viceroy Highway Licensing Panel. My name is Councillor Mandy Brown. I'll be chairing this meeting. The meeting is being held in person and via Zoom, streamed live to public on YouTube. I remind all attendees taking part in the meeting indicates consent to the audio and video being streamed live, and acknowledgement that after the meeting, it will continue to be available in public domain. We are not expecting the fire alarm to sound this evening. However, if it does, please may I ask leave in an orderly fashion and across the road outside the library next to the fountain. Firstly, it would be useful for all voting members, officers could introduce themselves so the public are aware of who's in the meeting and the role they undertake. Thank you. I'll start with
Catherine Lamprell. I'm bringing the officer report to panel this evening.
My name is Paul Wilmshurst. I'm a barrister in private practice, and I was appointed as the inspector into the Village Green application at Coombe Lane.
Good evening, members. My name is Katrina Herbert. I'm Head of Legal Services. I'm here to act as legal advisor to the panel this evening. Thank you.
The other boss.
I'm Simon Weller. I'm the Community Councillor.
A member of the panel.
Councillor Larkham, voting member of the panel.
Councillor Richard Coe, member of the panel.
Clive Baskerville, member of the panel.
and Vice Chair.
Oh, yeah.
Okay. I request a meeting, people taking place in the meeting do not speak unless I specifically invite you to do so. Once I have invited you to speak, before you do so, please state your name and the capacity in which you are speaking. If appropriate, I will ask officers to speak at appropriate times as well. If any individual attempts to disturb the meeting, I'm able to use my powers in the Constitution to adjourn the meeting and have the individual removed. I would also like to remind Councillor that to improve our time and effectiveness of the meeting, I would ask you all please limit repetition of points or questions which have already been raised by others. Where possible, please put forward all new points or questions which you would like to raise during the request to speak. We will now start on the agenda item. Do we have any apologies for absence?
Yes, Chair. Apologies received from Councillors Blundell and Councillor Hill.
Thank you. Okay. Approve the minutes of the meeting. Okay. Sorry, declaration of interest. Anybody? Any declaration of interest? No? Okay. So approve the minutes of the meeting held on the 20th of May 2024 as true and accurate record. Thank you. Now we come to item 4 of the agenda, application to register land known as Coombe Lane, Sunninghill, Ascot as a new village green. I will ask Catherine to introduce the item, please.
Good evening, members. I'm here today to present a report for decision by the panel as to whether or not an application made by Sunninghill and Ascot Parish Council, the applicant, to the Royal Borough of Windsor and Maidenhead in its capacity as Commons Registration Authority to register land known as land at Coombe Lane, Sunninghill as a new town and village green should be accepted or rejected. Members will have noted the legal requirements of these applications as set out in my officer report, but I'll provide a short summary by way of introduction. On the 1st of April 2022, the applicant applied for the land to be registered as a new town or village green pursuant to section 15.2 of the Commons Act 2006. The area is shown edged red on the plan attached at Appendix C of my report. A large piece of woodland, the land formerly comprised one area owned by a local resident, Mr. Mygand, but was sold in 2020 and is now divided into roughly 18 individual plot numbers A to R, shown on the plots plan at Appendix D. Please note the application relates to an area covering 17 of these plots. The 18th plot hatched on the application plan, known as Plot K, is not part of the application site. Sorry. Councillor Hunt.
Would it be possible when you're mentioning appendix
Mhm.
B or C, we have our PCs here,
Yeah.
and it's difficult to come off the agenda and onto those. Would it be possible to have them on the screen for everybody to see? Sorry, Auron. It's like giving
Are
you
you
a
able to do
headache.
that? They're numbered appendices. So you've got my report, and then it's appendix, I think, goes C, D, E, and F. So sorry, if it's okay with the chair, I'll just go back to the first member. So Appendix C, just to confirm the area that was applied to be registered. That's Appendix C is the application, and if you scroll down the application, Oren, you'll see a plan appended as part of that. Sorry.
So much better up there.
So it's a separate appendices, if that helps.
Yeah.
So not in my report
Success.
itself.
It's at the end, I think. Yeah.
Yeah. Yes, and if you scroll through, there's a plan. There we go. So this is the application site edged red, but as I then went on to mention, the area covers 17 plots. The 18th plot, which you'll note is, or which is hatched red, is known as Plot K. That's not part of the application site, just to note, due to the plot having been granted planning permission, an application for which was submitted prior to the 1st of April 2022. To register a new town or village green, an applicant must show that on the balance of probabilities, they have met the requirements of Section 15 of the Commons Act, namely that a significant number of the inhabitants of any locality or any neighbourhood within a locality have indulged as of right in lawful sports and pastimes on the land for a period of at least 20 years. In addition to the above, applications must also demonstrate either use of the land has continued as of right until at least the date of the application, or use of the land as of right ended not more than 1 year prior to the date of application. The particular application was reviewed and duly processed, and the council received 7 objections. As these objections raised issues of fact, and consulting the council's procedures for contentious town or village green applications and common law, it was considered necessary to convene a non-statutory public inquiry to examine the factual evidence, and the council sought to appoint Mr. Paul Wilmshurst, who's with us today, counsel experienced in village greens, as an independent expert to act as inspector and consider the application, evidence, relevant law, and test the same at a non-statutory public inquiry. The inquiry was convened over 9 days between the 28th of February to the 14th of March 2024, and 17 of the 18 landowners, and separately the owners of Plot K, formally objected. The inspector heard evidence for and against registration from the parties' counsel, witness testimony, and undertook an accompanied site visit. Following the inquiry, the inspector was required to provide the council with a written report. This is Appendix F, containing a recommendation based on the evidence and legal requirements for whether the land should be registered as a new town or village green in accordance with the requirements of the Act. Key points for consideration from the inquiry and following the inspector's report in relation to the application were: the inspector's decision required consideration of an alleged landowner statement under Section 15A to the Act made by Mr. Mygand. This is Appendix E of my officer report. The inspector was required to consider whether or not the council, despite asserting it did not hold a physical copy of such declaration, had, by way of evidence submitted and interpretation of legislation, nevertheless been deemed to have received Mr. Mygand's statement and thereafter the effect of deemed receipt on the application. For context, since 2013, any freehold landowner who has concern that their land may be susceptible to a TVG claim may deposit a statement in a Form CA16 to the council in order to protect their land from requiring such rights due to use over time, i.e. by prescription. The processing of landowner statements is set out in Commons Regulations 2013, and the inspector focused on the processing of these deposits by the council and legal arguments as to deemed receipt. If a landowner deposits a declaration on land which has at least 20 years use as of right already being obtained, the effectors that users of the land are put on notice that their access is no longer as of right, and anyone wishing to assert their rights will have 1 year within which to make a TVG application. E.g., a landowner statement initiates section 15.3 of the Act in the same way as a physical preventative use of the land, such as signage, fencing, or locks. Landowner statements are assessed on receipt of any TVG application, and inquiries were made in this instance, although the answer provided was the council held no record of having received any landowner statements pertaining to this land, other than in relation to Plot K. As such, the council proceeded with the application. Whilst the council continues to have no physical record of Mr. Migan's statement, in 2023, an email containing a copy of the council's register noted this statement within its list of deposits. The objector argued, therefore, that the statement was duly made and submitted this with evidence of correspondence between Mr. Migan's solicitors to his then purchaser's solicitors in November 2020, also referring to the deposit having been made. The timing of Mr. Migan's statement being sent during 2020 was also considered due to the changes in processing incoming posts at the council dealing with the ongoing COVID-19 pandemic. The inspector took into the account testimony of 2 objectors, Mrs. Williams, the owner of Plot O, and Mrs. Garner, the owner of Plot K. Mrs. Williams provided testimony that she had applied also to deposit a landowner statement with the council in February 2023, but this was confirmed as not having been received by the council in March 2023. The difference in Mrs. Williams' application to Mr. Migan's was that Mrs. Williams retained a proof of delivery receipt from Royal Mail showing the declaration had been received by the council. The inspector found on the evidence presented the statement had been sent by Mrs. Williams but had been lost by the council. After hearing and reviewing the evidence presented at the inquiry, for the reasons set out in his report, the inspector found the council had received an alleged landowner statement from Mr. Migand in 2020 in October that should be applied to the land and so applied to the application. Therefore, overall, the inspector found, taking into account the evidence from Mr. Migand's solicitors that he had deposited his statement, the complications with distributing posts during the COVID-19 pandemic, and that Mrs. Williams' subsequent statement could also not be found, that on the balance of probabilities, Mr. Migand's statement had been deposited in October 2020, and that in keeping with the requirements of the Highways Act, as to receipt, whereby the service provisions of the Highways Act 1980 provide that where services by way of standard post, documents will only be deemed not to have been delivered if they were proven not to have been received. Apologies. It could not be proven by the council the document had not been received. As the TVG application was not made until April 2020, the inspector therefore found the application must fail under section 15.3 as it was not made within the required 1 year of the landowner statement being deposited, the relevant period here being between October 2020 and October 2021. Secondly, as having indulged as of right, notwithstanding the inspector's conclusions above regarding landowner statements, he continued to apply the tests required under section 15.2 and 3 of the Act to the application. The inspector found the requirements of registration had been met by the applicant other than the requirement as of right due to the vast amount of signage on the land, and that the key issue in relation to the application was whether or not use had become contentious, an argument presented by the objectors. Contested use is an important consideration, as with landowner statements, such would then affect the application and timing of 15.2 and 15.3. The requirement for as of right to be demonstrated by the applicant is split into 3 aspects, requiring use of the land being without force, without secrecy, and without permission, or more simply, A, peaceable, B, open, and C, not based on any licence from the owner. Examples of contested use might be where an applicant has acted contrary to the land being locked, fenced, or signpost, or forced their way onto the land, visited by stealth or only in the dark of night so that no reasonable landowner could see their presence, or that access has been expressly permitted by the landowners. Aspects B and C, so without secrecy and without permission, were found to be met, but the inspector's focus turned to A, without force. Case law has found that force is not required to be merely physical, but maybe the actions of climbing or breaking down fences or gates, or use under protest, or in relation to the case at hand, if the landowner displaces opposition to use of the land by erecting suitably worded signage which is visible to and actually seen by local inhabitants, their subsequent use of the land will not be peaceable. The placing of signage does not always defeat a TVG claim, but is required to be assessed in the context of this application. Whilst the inspector noted the wide-ranging nature of signage on the land, his focus was drawn to two particular signs regarding private land, no public right-of-way, and high-risk fire area, no fire stoves or barbecues. In reviewing the evidence provided by the objectors referring to social media posts and internet photographs of signage in August and November 2020, as well as oral evidence provided at the inquiry, he found that they would have come to the attention to the users of the land, and the overall effect of such was sufficient to end as of right user on the land. As such, the inspector found that as of right ceased to be at the latest November 2020, and as the application was not made within the 1 year grace period required by section 15.3, the application cannot succeed. For the reasons outlined in the inspector's report of 31st December 2024, my office of recommendation is the application should be rejected, namely that the inspector has, on reviewing the evidence and after holding a non-statutory public inquiry, determined that an alleged landowner statement under section 15A of the Commons Act 2006, made by a previous owner of the land, Mr. Timothy Mygend, was received by the council during October 2020, and that the application being made on the 1st of April 2022 was not submitted within the 1 year grace period as required under section 15.3 of the Act. And notwithstanding the above, the inspector, in applying the tests required under section 15 of the Act to the application, also found that use of the land ceased to be as of right due to signage placed on the land by at least November 2020, and that as the application was not made within the 1 year grace period under section 15.3 of the Act, for this reason the application cannot succeed. In conclusion, it's not insignificant for a landowner to have their land registered as a TVG. The effect of registration would mean that local public have recreational rights over the land in perpetuity, and the landowner would be unable to develop or undertake works in contrast to its registration as a village green. That being said, the decision for the council is one of whether or not the tests under section 15 of the Commons Act have been met, and not the effect of whether or not the land is registered on either the applicant or the objectors. In this decision, there are aspects of council decision-making usually considered by members, such as climate change, EIA, aspects of saving green space. However, these should not be taken into account in this instance, as above, registration or not will depend solely on whether the element of the statutory criteria for registration has been met. The registration authority may depart from the findings and recommendations of the inspector if it considers it would be appropriate to do so, but would need to provide sound reasoning in law for doing so, as the findings, for example, for the findings to be unreasonable. In relation to the current application, officers have considered the inspector's report and make this recommendation pursuant to the recommendations put forward by the inspector and for the reasons stated in the inspector's report. Thank you.
Now, I think we got a public speaker, and Mrs. William have sent a written statement. So would you like to read it, Warren, please?
Thank you, Chair. So yes, as the Chair said, Mrs. Shanice Williams registered to speak, but she's unable to attend. So I'll just read out her brief statement. So these are in her words. I would like the panel to know I, alongside a number of other plot owners, have taken an open, honest and transparent part in the proceedings from the beginning till date. We all came together and welcomed the opportunity to give our evidence in full over a 2-week period to the inspector. We believe it was conducted fairly and impartially. The inspector listened carefully to all of the evidence from both sides and took his time to reach his decision, which was most certainly not an easy inquiry considering the length of time it took and the vast amount of evidence shared. It is clear that signs were up on the land prior to the relevant dates, and the inspector recognised the issues experienced with the submission of landowner statements. Based on this, we believe that the panel should adopt the conclusions of the independent inspector with regard to determining the decision of this TVG application.
Thank you, Aaron. Now I could call on Mrs. Garner as a registered speaker. We've got 3 minutes, yeah? Thank you.
Thank you for this opportunity to address the council. My land was exempt from this application. However, this process has caused me great upset. I had good relations with local people the year before the parish brought the application, but since I have suffered from vandalism as well as physical and verbal abuse from local people. I feel vulnerable on my land and I have needed to call 999 to remove unwanted attention from men. The inspector concluded private signs were present in the woods in August 2020 and were sufficient to end as of right use. If the parish had read their own witness statements, it was clear local people had seen those signs more than a year prior to the application date, yet the parish still took the decision to pursue the application in order to try and thwart development. This application would not have come about without being bankrolled by parish using public money. It has cost 50% of the parish's annual budget and wasted vast quantities of borough's money. The two councils have spent £200,000 on this application, which could have purchased 36,000 Meals on Wheels or 1,300 financial hardship grants for the poorest in the borough. However, parish chose to fund a TVG for the richest to be able to walk their dogs on private land when there is a public park 150 metres down the lane. The inspector also concluded Mr Mygans did submit a landowner statement in 2020 and that if the Borough Council had processed it correctly, the registration authority would not have been able to accept parish's application. The landowner statement is genuine, the signs were clear and present. So this 3-year torment should never have occurred. The inspectorate's recommendation is clear. Legally, there can be no TVG. Now the Borough Council needs to add the Mygans landowner statement to the Commons Register. They also need to recognise their responsibility for the mistakes in the legal procedure and accept any future financial liabilities for landowners whose registration has not been made correctly,
1
including
minute
mine.
remaining.
Is my landowner statement legally valid? Also, any suggestion of public access to Coombe Woods needs to be removed from both councils' agendas, including showing the private paths on the definitive map and recording the paths in the milestone document. We also believe, as it was parish and borough councillors telling people they had a right to use this land, that both councils need to publicly acknowledge that councillors were wrong and state public access must stop. This message needs to be clearly and widely displayed near the land, on websites and in all publications. Will the panel take this opportunity to state they will not condone fly tipping, arson, trespass, vandalism or harassment by anybody? And will they commit to fully assisting landowners to putting a stop to these actions of the public and councillors who are persecuting landowners who did nothing wrong in buying this land or exercising their right to privacy? The first steps towards this is to reject this TVG application. Thank you.
Thank you, Mrs. Garner. Now I will open it to the panel. Who would like to speak? Councillor Baskerville, please.
Thank you. I think the speaker made a question there to the legal department. Were you able to answer her point, first of all?
Sorry, in what respect?
Well, do you want to quickly repeat it?
Is my landowner statement legally valid? You won't answer that, council. You made a mistake. You did not advertise my landowner statement on my site. Therefore, technically, I appreciate that local people never knew I put in a landowner statement. Timothy Mygans, I presume, was never advertised either.
Can I bring your name, please? Because you're not
Thank you,
allowed to
Chair.
speak. You have already spoken. I'm sorry.
Yeah, so
Yeah.
it's all right,
So I'm
no
on
problem.
red. Can you hear me? This is red. Sorry, just as Councillor Baskerville did ask the question of Mrs. Garner, but just to clarify, But we're in correspondence with Mrs Garner in relation to this matter, but it's not a matter for this evening's panel. So the legal department is in correspondence with Mrs Garner in relation to this matter, but it's not a matter for the panel this evening. It doesn't touch on the decision-making in relation to the Town and Village Green application. Thank you, Chair.
Thank you. Have you finished, Councillor Bastable?
I just want to make, in the report, it was mentioned.
Just microphones, because mine's saying green, I'm not supposed to be speaking.
No, because green means you're in the queue to speak.
I was just something else to that speak.
Don't worry.
Did you want to speak?
No.
No, I'll let Councillor Bastable finish.
Yeah, I was just trying to, I don't know whether it's still germane to this meeting, but the point was made about the processes at the council, the fact that things have gone missing. I just wondered if the processes have been looked at and improved so that documentation is properly logged and registered as of now, as opposed to what happened in the future. I mean, I was aware of the fact that these things were happening at the time of COVID and that sort of thing, but it still reflects badly on the council, the fact that they weren't properly logged, in my view. And I just wondered if those processes have been looked at and improved.
May I ask you to answer? Okay, Katrina.
The department dealing with these matters is reviewing its processes and procedures in light of the inspector's findings. And it is an unfortunate set of circumstances, there's no doubt about that, but you have the inspector's reports and findings in regard to the evidence that he heard about that point.
Thank you, Katrina.
Thank you.
Okay.
You finished, Councillor Bastable? Councillor Coe, please.
I wonder, first of all, if anyone on the legal team present could confirm for particularly residents watching at home that the decision we're making tonight is a quasi-judicial decision and we aren't in a position to make a decision on our views of village greens per se. And the second point is it my correct understanding that the owner statements are in force as if received, even though there's been obviously some problems with their registration?
Chair, if I may take the first point, and if Catherine could take the second point in relation to landowner statements, because that's germane to the subject matter of the report. In relation, yes, this is a quasi-judicial process. Members have the inspector's report. That is the legal process by which this matter must be processed. It has been processed by a non-statutory public inquiry being held, and an inspector independent of the Commons Registration Authority has reported on that process. So members must follow procedure, sitting quasi-judicially. They must act fairly and impartially and in a fair and transparent manner. And to assist you in that regard, this evening you have a very detailed inspector's report and Catherine's very detailed report on that report. And it is lengthy, it is detailed, but that, by having regard to that report and following the recommendations, members will be meeting their obligations in regard to their quasi-judicial decision-making, if that assists.
Thank you.
Thank you.
Catherine?
Hopefully this answers your question, Councillor Kate. I'm not trying to divert from your question in answering it in this manner, but the legal team itself doesn't deal with the deposits. It's a different department that deals with that, so I can't speak as to individual deposits because I haven't been involved with that myself. For Mr. Mygan's deposit, obviously you'll note the inspector's findings from any deposits other than that. I understand the council department responsible is processing them. And as Catriona mentioned, they've reviewed their processes in light of the inspector's findings also. Does that answer your question?
I think my question is,
Sorry.
Are we in reaching a decision to treat them as if they were properly registered? I.e., my reading of the inspector's report is that the original statement, which I think was 2020, counts as if it was in force, even if it wasn't properly advertised.
I see.
Perhaps I can.
Yeah,
Of course.
okay.
Yeah.
the legislation under the Commons Act, as it was reformed in 2013 by the Growth and Infrastructure Act, introduced landowner statements. But the legislation provides that the landowner statement has effect when it's received by the Commons Registration Authority on the day that it is received. So if, for example, it was received in the office, but then there was a month before the actual register of those landowner statements was altered, it would be the date that the statement would have effect is the day that it was received and not when the register was changed.
Thank you, that's very helpful.
Thank you. You finished, Councillor Cole? Yes. Councillor Werner, please.
Thank you very much. Obviously, it's deeply embarrassing what's happened in the past under the previous administration with the loss of documents. And you know, we came to power committed to fixing the mess we've inherited, and we'll make sure that that kind of thing doesn't happen again. But my understanding from reading the inspector's report is that that mistake that was made, he would still, even if it hadn't been made, he would still have come to the same conclusion as a result. So really, it's not relevant to our decision here. My understanding on this is that, well, perhaps you can tell me, what are the consequences if we did approve this against the recommendation of the inspector? What are the sort of financial and legal implications of doing that?
Catriona.
Chair, the members would be at risk, in my opinion, a high risk of potential challenge with regard to reasonableness and fairness of such a decision in light of the inspector's findings and the reasons for those findings. So I would urge caution if members were considering that, and we would need to have a very thorough look and consideration of any reasons, but I think you'd be in some difficulty to come up with any robust defensible reasons. And the law, as it has developed in relation to town and village greens, where there is a non-statutory public inquiry and where an inspector has reported to the Commons Registration Authority that the Commons Registration Authority, and that's members are sitting as the Commons Registration Authority this evening, must have regard to that decision to the extent that they should follow it unless they have very, very good reasons for not following it. And in the circumstances of this application and all the evidence that was received by the inspector and detailed by the inspector, I don't think members would have such grounds. But obviously, members are here to discuss and debate. Thank you.
Thank you, Catriona. Councillor Larkham, please. Oh, sorry, have you finished? Yeah, so, sure. Councillor Larkham, please.
Thank you, Madam Chairman. Would it be proper of me to propose that we accept the inspector's recommendation at this stage?
Okay, seconder. Councillor Basketball. Okay, anybody else like to speak before we go to vote? Councillor Hunt.
I just wanted to thank the inspector. That was a very, very explicit document produced. And I'm so pleased I read it before because quite frankly, I couldn't, you went on a bit. So I like to take my time going through what the wording was. And so I'd just like to thank the inspector for that.
Councillor Werner.
Thank you. The public speaker also mentioned the behaviour of some of the councillors on Sunninghill Parish Council. Would the legal officers like to comment on whether they perhaps overstepped the mark, and some of the borough councillors that were in power at the time?
Catriona.
Chair, through you, no, I wouldn't like to comment on that with respect, Councillor Werner. This process is a lawful process. It's open to interested parties to make the application. The parish council saw fit to do that. The parish council was legally advised. I can't comment on their decision-making process in that regard, but they were fully legally represented, as I understand it, at the inquiry, with solicitors and a barrister, I believe. So they clearly took, I can only surmise that they took good legal advice, good solid legal advice, and they thought that they were in with the shout. So I can't, it's not for me to criticise or to pass comment on the decision-making process for them to bring that process, but all I can say is that process is available to be implemented, and the process has been gone through in a proper and fair manner. Thank you.
Thank you, Katrina. Before we go to vote, I'd like to thank the inspector and the legal officers for all their hard work, and it was very clear, the message in the report. Obviously, the decision we're about to make I believe is the right decision. Could I go to vote now, please? Could I have named vote? Yeah, if possible.
Yes, thank
Yeah.
you, Chair. So the motion has been proposed by Councillor Larkham, seconded by Councillor Baskerville, and that is that the Rights of Way and Highways Licensing Panel notes the report and rejects the application for registration of a new town or village green in respect of land known as land at Coombe Lane at Sunninghill, Ascot, as it fails to meet the test for registration under Section 15 of the Commons Act 2006 for the reasons set out in the inspector's report dated 31st of December 2024. It confirms that the land at Coombe Lane, Sunninghill, Ascot should therefore not be registered as a new village green, and confirms that written notice of the outcome giving reasons for the decision to be given to the applicant and to the objectives, and that notification be published on the council's website. I'll do a name vote. If you could please tell me if you're for, against or abstaining. Councillor Baskerville. For. Councillor Bra.
For.
Councillor Coe.
For.
Councillor Hunt.
For.
Councillor Larkham.
For.
Councillor Werner.
For.
That's unanimous, Chair. So the motion passes.
Panel members and officers and the inspector for attending, and obviously the speakers tonight. The meeting